My name is Lisa Plensner. I'm the division manager for the federal clerk's office here in South Bend. We're about to get started. I know in the previous session some announcements were made. And now I'm completely forgetting what those announcements were. But I'm going to ask you, yes, to please fill out and turn in the blue form that Ms. Berta just waved around. And bring one up to make sure you get your CLE credit. As a courtesy to our speakers and the rest of the audience, please remember to silence your cell phone. If you're looking for Wi-Fi, the network is H Honors, and the password is 1981. I have the pleasure of introducing Candace and Stephanie. Candace Kilpinen is the career law clerk to the Honorable Michael G. Gutch Sr. Since 2002, Candace has served as the career law clerk in the United States District Court for the Northern District of Indiana for United States Magistrate Judges Michael G. Gutch Sr. and Christopher A. Mechterlin. Candace has supervised more than 60 legal externs, mentoring them on principles of litigation, general legal writing, and judicial opinion writing. Candace taught legal writing and reasoning to first-year law students from 2011 to 2012 at Valparaiso University School of Law. A second career lawyer, Candace worked in the field of education before attending law school. Experiences include assisting high school students as college admissions counselor and inspiring younger minds as a preschool teacher. Candace is a sports fan with a big heart for the Oklahoma Sooners, the Chicago Cubs, and the Detroit Lions. Candace travels regularly to family in South Dakota, Tennessee, Colorado, Arkansas, and Michigan. And sitting next to her is Stephanie Mullaney. She is a term law clerk for the Honorable Michael G. Gutch Sr., United States Magistrate Judge. A South Bend native, Stephanie graduated summa cum laude from the University of Notre Dame in 2010. She then attended law school at the Indiana University Maurer School of Law in Bloomington, where she worked as a managing editor of the Indiana Law Journal and as a certified legal intern at Indiana University Student Legal Services. After graduating from law school in 2013, Stephanie spent 1 year clerking for the trial court judges in Montgomery County, Indiana. Stephanie then spent several years working in state government, first as a staff attorney for the Indiana Office of Inspector General, and then as a deputy attorney general in the advisory division at the Office of the Indiana Attorney General. Stephanie moved back to South Bend in March 2021 to be close to family, and she lives with her husband Dan, daughter Lucy, and dog Ernie. And you will also note that if you read the biography, Stephanie enjoys, not only are Stephanie's favorite restaurants, Rocco's, and what was the other one, Stephanie? I'm sorry.
Jesus.
Oh, and Jesus, I'm sorry, but those are also her favorite books.
And yet I'm here presenting on technology.
So may I present Stephanie Mullaney and Candace Kilpinen.
So if you were here for the last presentation, I don't know how Judge Lichty did what he did. I'm just using YouTube.
Meet George Jetson. His boy Elroy. Daughter Julie. Jane, his wife.
So the Jetsons is a quintessential example of technological advancement, so it's the perfect theme for what we plan to talk about today. But we really wanted to set the stage for this, so we decided to take just a little creative license with George and Jane. So instead of George Jetson, digital index operator at Space Lease Rockets, and Jane Jetson, homemaker, we would like to now introduce you to George and Jane Jetson, new attorneys and owners of their own law firm.
Our first day at our new law firm, Jetson & Jetson, LLP. I'm so excited. Aren't you excited, George?
Jane, it's so early. I never had to be at Spacely Sprockets this early. You promised we wouldn't work more than 2 hours today. So why do we have to get here so early?
Oh, stop complaining. I told you we had to hurry up and get started right away today because we already have our first big case.
Our first big case?
Remember, it's that big aero car accident. It happened almost 2 years ago, so we need to file our complaint soon. And one of the people involved lives in another planet, so we need to figure out how we can serve them and how much time we have.
Hooba dooba, that's a lot to figure out.
It is. So I think we should split things up. Do you want to draft the complaint so that we can get it filed by the end of the week, or do you want to figure out the service issue?
I'm getting a compact saucer cramp just thinking about how much work this will all be. But I guess I'll take the complaint. Wait a minute. We have all that new AI technology. If I use that, I probably won't have to do anything at all. Okay, let me just start by pushing this button. Jane, how do I stop this crazy thing?
I have so much I need to do to research and write up for this case. Where do I even begin?
Thank you for laughing. This was the part I was most nervous about. So, George and Jane raised the two main questions we plan to address during the presentation. First, we hope to answer Jane's question, where do I even begin? By discussing fundamentals and best practices for good writing. We'll highlight writing practices that are more problematic as well. And these are issues where parties can risk miscommunicating their arguments to the court. From there, we hope to address George's question, how do I stop this crazy thing? By discussing some of the technology that's available to us for use in our legal writing. We'll talk about how it can be a valuable tool for writing, but we'll also focus on ways technology can be misused, discussing ethical issues that are related to the use of technology. So with that, I'm going to turn it over to Candace, and she's going to discuss how Jane should get started.
Thank you, Stephanie. As a preliminary matter, thank you, Lisa, as well, for the warm introduction. I would be remiss if I didn't correct one little thing. I have only been working for the court since 2012, not 2002. So I just didn't want there to be any confusion out there in the world. So we'll end with that.
She's so good that it feels like she's
Well, I don't know about that, but it's been a joy the whole time, so thank you. So let's start talking about the fundamentals and best practices for legal writing. And I'm going to start a little bit talking about ideas behind how we prepare and execute our written work product. As Judge Gotch's law clerk, Stephanie and I both have quite the bird's eye view of legal writing in the 21st century. And what we see is that really the best legal writing in the 21st century does not stray very far from the best legal writing in the 20th century. And especially when you're writing for the court, we really see that the benefit of planning so as to communicate effectively, persuasively, and completely. And it's with that in mind that we often see writing that comes in that seems to give us pause because it seems sometimes as if the legal arguments are being posited without always a thorough and clear understanding of the underlying law. So we would encourage in that preparation process to always have the facts and law, know that like the back of your hand, dissect the applicable statutes, procedural rules, case law, before you even get started thinking about what you're going to write up. But then we like to think about, we have looked at a variety of the legal writing processes that have been developed by legal writing scholars out there, and this is one that we have come to appreciate, so we'll give you just a quick glance at this. Many of you may have seen it over time. It is definitely a 20th century paradigm. Betty Flowers was at the University of Texas in 1979 when she came up with this, but I think it still works. The madman, architect, carpenter, and judge. And this paradigm really is a healthy reminder for us of the 4 intellectual functions that are involved in good writing. And it starts with creativity. That's your madman, who is generating ideas on and how to, about the law, the applicable law, understanding the law, matching those up to the facts in question. Planning, as our architect does, a structure that is going to be sure to create a sound and appealing argument. And then, and essentially creating a blueprint for your carpenter, who then comes in and does the drafting. So there's a lot of work that goes into the writing long before you ever put pen to paper or fingers to the keyboard, as the case may be. And then the last role, the last function in that writing process, they call it the judge here. I think of it as the proofreader extraordinaire. And with that, then you have a good plan that takes into account a lot of the problems. As I alluded to at the beginning, one of the problems that we do see is evidence in the writing that comes to the court of soundbite research, or looking for legal authority to support a predetermined proposition rather than devising an argument based on a solid understanding of the applicable law. And planning like this hopefully puts you in that position to do a better job of avoiding that pitfall. We see it all the time. In fact, I was talking with one of our externs yesterday about a brief where it was evident that the lawyer had cherry-picked attractive language from a case, but hadn't really considered the totality of the case, and as a result ended up kind of citing to inapplicable, even adverse authority to their position.
I see the latter a lot, where the case will say what the lawyer says it does, but when you actually look at the case, it's the opposite of what they're asking for. And I'm kind of speechless when that happens, because I'm just not sure what to do with that.
Yeah. Well, and it's a real risk. It's not what you intend as lawyers when you're trying to communicate with the court as well. Similarly, we see a lot where principals are cited with a great case, but no pinpoint cites. Same thing can happen with the factual record with no pinpoint cites, and it leaves then the judge and his staff to have to figure out exactly what are we using this case for, and how does it apply to this particular fact pattern? What evidence is it that you really want us to see? And anytime that happens, unfortunately, it ends up taking longer, usually, to get things done on our end, because there's more that we have to do to prepare. I don't like to think this is the case, but there's always that possibility that those kinds of things can annoy a judge as well. So those are some of the risks that come with not giving care to the preparation. All right, so let's talk a little bit about what a good preparation and execution of a writing plan could look like. I start by saying we fully recognize that there is no singular correct method of what I'll call pre-writing, this planning and preparation stage. Each of us as lawyers brings our own personality and writing style to bear, and so each of us in this room are going to do this a little bit differently. But what we do see with the best writers is that there is a plan, even if it varies sometimes from project to project. Sometimes it's about the facts you're given. Sometimes it's about your familiarity with the law. Sometimes it's about who's the judge that was assigned. There's a lot of different things that are going to affect how you organize yourself. But use this preparation process to help you determine your strongest arguments and to figure out how to organize them in the most persuasive way. Indeed, this process, this pre-writing process, can actually be your checklist to ensure that you're drafting a brief that is going to cover all the necessary facts, arguments, legal authority, and even procedural issues. So you start with an idea of a roadmap. We use that word a lot in legal writing in different ways, but in this planning process, making sure that you start with a concise and clear statement of what you're trying to do. It may be as simple, working for a magistrate judge, we see a lot of discovery motions. It may be as simple as what you're trying to do is to get the other party to produce the discovery that you've asked them to produce, and you need the court's help to do that. It may be that simple as to what you're trying to achieve. But whatever it is, make sure you know very precisely what it is that you're asking for. Then make sure that you understand the legal standard that applies. Because if you don't understand it and communicate it well in your brief, who knows? Who knows what the court will do with that? They're going to need that information to rule on your motion, so make sure you're putting forward the proper legal standard for your situation and for your client.
Otherwise, you're trusting us to figure it out, which you may or may not want to do.
Yeah, that's your choice. That's your choice. Then you can start to, in the planning process, lay out your arguments so that you're applying your known facts and to that legal standard. And you'll want to keep in mind as well that when you're filing briefs, there are procedural requirements. We speak from the realm of federal court here in the Northern District of Indiana. Examples of that here are for a discovery dispute, for instance, Local Rule 37-1, many of you know this, requires a separate certification that you have tried to meet and confer and solve it before you get there. So don't forget about those little things. They can trip up even the best of us. And so this planning process ensures that you've inserted those in there. So we've got the planning process, the pre-writing done to an extent. As you get into writing, then there are some other issues that we would like to offer you some insight on. And Stephanie's going to start by talking to you a little bit about context in your writing.
So we've alluded to this a little bit already. Can you guys hear me okay? It feels very quiet to me. We've alluded to this already. Judges are generalists, or most of them are. So if your case involves any knowledge of a specific area or a certain industry, and pretty much every case will to some extent, your writing needs to give us enough context to understand what your case is about in order for it to be persuasive and effective for us. So the best way to do that is to make sure that you give us enough facts and legal context as part of developing your arguments. I think there is sometimes a tendency, especially, I don't know if it happens in more dispositive motions, but stuff that we see, discovery motions or extensions or other things like that, I think there's a tendency to jump right in, and that can sometimes be to your detriment. So I'm going to go through just what this can look like. This is just an example of the different things that you can put in to your motion to make sure you're giving us enough context. Of course, depending on what your motion is, the amount you'll have to do these things will vary. If you're asking for an extension of the case management deadlines, I don't need you to reiterate the entire complaint or anything like that. But sometimes it can be helpful to tell us the type of case you have or who the parties are or even what happened. And this can be, from the complaint or from discovery, and I'll kind of tie that in. Even on a more simple extension motion, sometimes having that can help us understand maybe why something is taking so long. maybe why you need more time to get those depositions done. So it's not something that you need to spend a lot of time on sometimes, but it can always help. The other thing you want to do is make sure that you give us facts explaining basically how you ended up having to come to us, how your dispute arose, why you're requesting what you're requesting. And I've alluded to this a little bit already, but taking the time and the space in your motion or brief to do this, it has a lot of benefits for you and selfishly for us. It's the chance to present the dispute from your perspective. So if you put some things in from the complaint, it's another way to talk about how the defendant was totally wrong. You can tell your side of the story. It also, as Candace has talked about a little bit, it helps you make sure you've covered procedural requirements. So like she said, we work for Magistrate Judge Gatch, George Jetson. So we see a lot of discovery motions, and a lot of things we see coming up on motions to compel, for example, is our local rules require a separate supporting brief and a separately filed certification that you met and conferred in good faith to resolve the discovery dispute before you came to the court. And we see a lot of motions that don't meet the technical requirements. Maybe it's all in there, but it's all smashed into one filing. And maybe it's not really fleshed out, and we can't always tell if you adequately met and conferred. So by taking the time to think about the facts of your case and putting everything in the context, it can help trigger you to check the local rules and make sure you're putting everything in the right place. So it can really help you with that, even if what you prepare in terms of your context is what you put into your motion. Your motion and brief should also provide us with appropriate legal context. So basically, you want to tell us what are the issues before us and what you want us to decide. This is one area that can sometimes be overlooked in our discovery motions is people will forget or they'll leave out just a brief overview on the substantive area of law. I mean, I don't need a whole treatise, but sometimes if you give us a paragraph or the main standard, it really can help us understand why you think something is relevant and proportional to your case, or why you think the thing that the other side is asking for is not. If you don't do that, you're leaving it up to us to read about the substantive area, and I might have a different take on it than you, and I won't have the benefit of your perspective. And of course, you want to give us a standard for review for whatever type of motion you file. And this basically will just help you ensure that the arguments that you make are framed and connected to whatever your burden is or for whatever you need the court to do. And again, this is another way you can make sure you've met your procedural requirements as well. So on this slide, I just have a couple of examples of some things that we see where I think that if people spent a little more time on context, you wouldn't have issues. So first, thinking about procedural requirements, our local rules require you to file a copy of the discovery at issue with your motion. And then thinking about making sure your arguments are tied into the standard and into your context. To modify a case management deadlines or an extension of time on a motion or brief, you need to show good cause. And same with filing a motion to seal. I think sometimes, and they often can be, people will think these things are kind of a foregone conclusion, especially if the other side doesn't object. But we still need the good cause to be able to do what you're asking us to do. You know, you don't necessarily maybe even have to use the words good cause, although I like seeing it because I know that you know what you're supposed to be asking for. But there are times when we just get motions asking for an extension and there's no explanation at all about why additional time is needed, and we're kind of stuck and there's not a lot we can do. So taking the time to set up your context and think it through, even if you don't translate all of that into what you file, it will help you make sure you include all the information you need to. And it will give your arguments something to stand on when you move into developing that part of your motion or brief. And it will make what you're asking us to do flow a lot more logically, and it makes it easier for us to give you what you want, and we can do it more quickly, which usually makes you all happy. And I think a lot of the problems we're going to discuss throughout the rest of this presentation, and a lot of the problems we've alluded to already, these can all be avoided if people took more time to make sure they know and set up the context of their filing before they actually file it. So Candace has a lot more to say on this, and she's going to expand on it and do a much better job than I did. So I'm going to turn it back to her.
So some of the things we've observed over time, we often will get briefs that come in, and they do a fantastic job of presenting arguments, affirmative arguments for the position of that particular party. But they fail often because they don't always engage with strong arguments on the other side. And there's no question that actively engaging and rebutting opposing arguments can be very difficult. But it really is necessary for you to be able to maintain control of the message you're sending to the court. If you don't, and this isn't, none of what we're sharing should be new to any of us. We since day one of law school, we've all been hearing these things, but hopefully the repetition and the experience that we have can help to encourage you to think of things in a slightly different way.
We talked about this. If you care enough to show up at a legal writing presentation, you're probably doing a lot of these things already.
That's
so
correct.
it kind of feels like preaching to the choir a little bit, but I still think it's helpful to think about what you're doing and apply it in a different way.
That is correct. No, that is a good addition. And yeah, you're fine. Let's see. And I guess then the other thing I would say about that, about making sure that you maintain control of the message and confronting opposing arguments, beware, because if you don't confront that opposing argument, you run the risk of basically forfeiting the point. Undeveloped arguments are waived. It's one of our favorite things to say, and unfortunately we see that more often than we like. It doesn't always mean you lose, but it can mean that you lose, and you don't want to take that risk. And again, that is kind of one of the concerns that we want to be sure you are aware of. And it's also always important then to understand what you're doing. So burden of proof. Stephanie started talking about the burden of proof. This is where if you don't acknowledge this, you might end up again preventing the court from being able to rule on your behalf. So take, for instance, we keep using our favorites because we speak from this experience, but a motion to compel, for instance. It's real easy to remember that whatever your burden is, if that, as the movant, somebody seeking some discovery from someone else, you have the burden to show that it's relevant and proportional. The request, the information you're seeking is relevant and proportional to the needs of the case. Well, yes, but it's also really important if you are saying, the non-movement saying, I shouldn't have to produce this, to remember that you can't just say it's not relevant, it's not proportional. You have to actually cite specifically why it isn't. The case law out there requires us to demand a showing of specificity as to why a particular discovery request is improper, because the scope of discovery is extremely broad under Rule 26. So, make sure that you take into account the full burden of proof and don't just focus on what you have to prove. You may have to think about what the other side has to prove to make sure that your arguments are complete and persuasive. Similarly, Stephanie alluded to the good cause requirements. The good cause requirement shows up in lots of different places. Keep in mind what that means. You've heard it a million times, I'm sure, but it's due diligence. And so if you're going to give us context to help us see good cause in any motion, remember it's not just because you have the best argument, it's because you've shown us that you've diligently worked to try and get discovery completed. You've diligently worked to try and resolve a dispute. You've diligently spent time trying to get depositions scheduled before you've come to the court for help. And that diligence, that due diligence, isn't always evident in all of the motions that we see. So keep focused on that. We don't get real excited, let's put it that way, when the end of the discovery period comes and there's a motion to compel or extend the deadlines, and there's no showing that the parties started discovery before 2 weeks before the deadline. That doesn't get us very excited or demonstrate the good cause.
And then they want to take 12 depositions.
Right, at the end. So keep that in mind. Another thing to keep track of as well is one of the symptoms of a failure to engage with the opposing argument or the burden of proof in your writing is, and how we see it, is in a proliferation of unsupported conclusory statements. This is how it is. It's relevant, Judge. It just is. Doesn't help us much, doesn't give us what we need, and doesn't end up helping you. These, again, can end up being concessions because they're undeveloped arguments. And any initial dazzle of this statement, and it can be very dazzling when you stand up and are forceful and really make a attractive point, but that dazzle quickly fades when there's nothing behind it. So keep that in mind as you're preparing your writing and engaging with all of the arguments. More tips here on what writing needs to accomplish for us.
So we've talked about how you should prepare. We've talked about giving it context. Candace talked about engaging in the arguments and engaging with your burden. So you've written your brief, you've written your motion. The goal should always be that your writing is seamless. That means that the judge or us, we can start at the beginning of your motion and read all the way through, and you don't have to stop. But there are a lot of things that people throw in there. I think they can feel like they're good writing, but they're things that can make us pause. These are arguments that are missing logical steps, sentences that are really complex or overly wordy, and language that's imprecise or abstract. Sometimes, even worse, they not only make us stop, but we basically have to put everything aside because we're spending our time trying to figure out what you're saying or diagramming your sentences, and that's not what you want, especially if you spend all the time to do pre-writing and set up your context. So I like to think of the clarity behind your writing as having two levels. If you take the time to do pre-writing and set up your context, you're going to have clarity. You're going to have clarity at least on a larger structure and with the overall logic of your writing. So basically from there, it'll just require you to go through and make sure that you've done that. And so some ways that I like to go through once I've written a draft to make sure I've sort of met that overall structure and that big picture clarity, I'll go back to anything I did in pre-writing. What did I say was my roadmap? Is my brief, is my writing set up to actually answer the question I put in my roadmap? We've seen filings where there's a lot of stuff in there that doesn't really get to the point. And it doesn't really answer the question that I assume they were setting out to answer. And so I always like to do that as a double check to make sure that I'm not also doing that. Sometimes you do want to put stuff that maybe doesn't directly answer the question in your writing, but maybe that's the time where you think about, does this need to be in my brief or at all? Does it need to be a footnote? And so this is kind of the stage where I'll work into that. Another way you can do this is if you put a lot of headings in your writing, maybe it's one of the 25-page briefs that you're submitting, and so you have headings and subheadings, I'll kind of take those and make an outline. Does that all flow? Does that all fit? And just make sure that everything is broken up the way that I think it should be. From there, I'll sometimes drill down even further. I'll look at maybe the first sentence or the introduction paragraph of a section, and I'll read just that. And if I can still trace my logic from there, I can feel comfortable that I've met that big picture clarity. So from there, I'll drill down and look at my individual writing, the language I used, how I structured my sentences. And this kind of gets to the point I mentioned earlier, where there's a lot of things that we as lawyers do where I think that they feel like they're good writing, like it feels very lawyerly to do certain things, and it's actually not good writing. So just a few examples. We all do this. I have to do the check on myself a lot. Overuse of legalese. We all use acronyms, and that's great. But sometimes it's problematic when you don't actually explain what they stand for to start with, or it's problematic when you change the acronym or like the short name for a party, because then I'm like, is this the same person? Is this a new party? And so it's just stuff that makes me pause. It makes me question who this is and what's going on. There are also industry-specific acronyms that people will use without explaining, and I'm usually totally lost. Last time we gave this presentation, I called out the RV industry, and I really didn't mean to do that. I was newer then and just didn't know a lot about RVs. You also want to avoid visual or substantive crutches to clarity, and I think these are things that people think that it makes what they're saying more clear, but this could be like putting words in bold or italics or underlining, or sometimes all of those things at once, and caps, and it hurts my eyes, and it kind of just makes me think you're angry. Like, I don't think you're being any more clear or persuasive, and sometimes I just have to like skip over it altogether. So if you have to prove your argument by putting things in boldface and underline and italics and caps lock, you're probably not being clear enough. So it's a time to step back and really scale back. I do think like a well-placed italic or a well-placed bold, like once, maybe twice, can work, but that's not the norm. You also want to avoid parenthetical definitions, and one iteration of this, and I do this too, so I kind of feel bad calling it out as an example. Writing numbers and figures and letters, like 25, 25, like, you can just pick one, I promise.
I do that. Yeah.
I do it too, so that's why I'm like, I don't know why I feel bad saying this. So I'm going to give it back to Candace. She's going to just kind of talk about this in a little bit more detail, and she's going to segue, because there's a lot of things at this stage of writing where technology can really help us, so she's going to bring us into that part.
Yeah, indeed. So what this takes us to is kind of the last part of the writing process, and where all of us, we've been tending to details all along. Even in the preparation, lawyers were trained. We're kind of, actually, people don't like it when we show up and we want to read everything because we're so attentive to details. But in writing, sometimes we have to be careful, and we need to spend just a few minutes. We don't have many minutes in our days, but just a few minutes to make sure things are right. And there's a reason that it's important. Even technical errors, spelling, commas, inconsistent name references, lack of pinpoint sites, even these little things that may not in the end say much, if anything at all, about what you're trying to say substantively, again, they make your reader stop. Because I'm like, well, shouldn't there be a period there? Why isn't there a period there?
Is this the same defendant?
Is this the same person? Yeah, what's going on? So anytime you have to stop, and it decreases the impact of your arguments when we have to stop. So making sure, it's hard enough, the job of the lawyer, to present strong, persuasive arguments on the real things that matter. Don't let us, as the reader, get distracted by the little things, because it will affect the impact of your argument. And second of all, I've seen Justice Scalia, some of Justice Scalia's writing on this. He's explicitly said it totally casts doubt on your substantive work. If you can't be careful enough with the periods and the commas and the spelling, as the court, why should we be convinced that your research was any good, or that you've got the right cases, or have understood the proposition of the cases you're using properly? So yeah, don't let your reader, in this case, as we speak here, the court, don't let the court get confused at all or sidetracked because of an inattention to detail. And so what that looks like to me, Stephanie has talked about it as well, but this is where you get into that last stage of the flowers paradigm, the judging. You can talk about everything else, but be a proofreader extraordinaire. Use all of these things. So Stephanie pointed out bold, italics, and those kinds of things. As I'm going back and proofreading, I have all kinds of things. If my brain stops, it makes me question. Doesn't mean I change things, but if I see italics, I say to myself, well, there's italics. Are they there for a reason? Or can I say that, am I not saying what I really need to say here? Can I change out a couple or add a couple of words to this sentence so I don't have to use italics and actually communicate what I want to do? I think there's just so many of those things. Any of those pauses in your reading are good cues to you to say, what can I rewrite here? Even as simple as, there's one word hanging at the end of a paragraph. All right, who cares? Doesn't really impact things much. But if I take that in my proofreading role as the judge of my own writing, and I say, well, can I write this better so that I don't have that one word hanging there driving me crazy at the end? I guess that says something about my problems in
Well,
life.
I mean, if you're up against the page limit too,
Yeah.
that can be another way to get another paragraph into.
Correct. So there's multiple reasons, but in a substantive way, anytime I see it, I just force myself to say, what have I written here and how can I make it better? And I guess I would encourage you, as you're going through and you're reading, trying to come up with that final seamless work product, make sure that you review every aspect of the draft. You definitely want to think about commas. But you also need, in terms of substance, what is your organization? You've outlined your headings. Does it really work? Are your ideas flowing? Have you missed an important element in your legal standard that you haven't applied? And of course, then you're checking spelling, grammar, and punctuation. Citations. That incorporates a lot. Are your citations, are you using binding or persuasive authority, and have you accounted for it appropriately in your argument? Have you taken the time to update your law? And of course, the bane of all of our existence, the Blue Book. And I guess I'd suggest to you, we aren't really Blue Book snobs.
It kind of seems like it.
We really aren't, as long as we can find it. But what we would say to you is pinpoints. Don't forget the pinpoints. And use that as another one of those reminders. If you see a citation that doesn't have a pinpoint, well, now that's a clue. Have I cited this case well? Have I used it appropriately? Is it the proposition that I actually want it to be? And it gives you just that one more check on your substance as well. So these things do tend to overlap. A few minor 20th century tips. Read your pieces aloud to yourself. And we'll start to get into the technological options. Microsoft Word has this thing that's really amazing that it'll read to you. And this is especially helpful in substance. I encourage, if you still are concerned about spelling, spell check, grammar check, all good. But also you can read your piece backwards. Now you're not wrapped up in the sentences and you can see punctuation and spelling errors and outlining your draft. So some thoughts. Proofreading is huge. I'm a big proofreading advocate. But with all of this in mind about planning and context, engaging, proofreading, clarity, we now think we've given Jane the vision she needs to start her little project. And but we noticed at the end there she was hesitant not just on how to get started, but she probably doesn't understand the full range of technological options that are available to her. I would say we're going to end up talking a little bit about technology here. We know this much about it, and you know this much about it, and there's this much of it out there. So take it as little segments to just generate ideas and take back to the office to explore some things on your own. But this concern out there about technology has been there for centuries. I found a 1974 article in the ABA Journal talking about word processing. And it's, oh my gosh, it's going to change the practice of law, and how are we going to deal with this? And it's, the same thing. Then I looked, there was an ABA Journal article this month on AI. Oh my gosh, it's going to change everything, right? So we hear these things regularly, but we don't want to be afraid of it. We want to be able to take it in and use it to our benefit. And I think that there are many technologies out there now. We kind of have been thinking a lot ourselves about AI for a variety of reasons. But there's a lot of the AI resources and some existing technology you've been using for a long time that are really great resources to you. So in terms of research, we've all been using electronic databases for a long time. We've got Westlaw examples up there because we tend to use that more often, but I suspect that all of them have these same types of things. Just general natural language searching, being able to do that even with Google as a tip that gets you a word, a search term that you can then put someplace else and really generate things. This is a technology that's huge. We see it in Westlaw, they call it recommendations. You hang around long enough and they start telling you what you need to know. They start sending you these things, so don't be afraid of it. Drafting assistant, if you aren't aware of this or haven't used it, it provides opportunities to help you locate authority. You can actually ask it to help you a little bit more take advantage of what the databases have in their systems. And the more modern things that we're all a little bit crazy about right now is the idea of generating written drafts, generating things, ChatGPT. In the 6 months we've been prepared, we've known we were going to be doing this. I don't want to suggest we've been preparing for 6 months. But in the 6 months we've known about this, we keep seeing new programs, new systems. And so at the end of September, Microsoft Copilot came out. I didn't even know it existed. I happened to stumble across it. It does some of the same kinds of things. I'm sure they each have their own benefits, but they're all out there. I can't say I've tried them, but I have heard lots of stories, and I would suggest to you that it's not all evil. And if you've got writer's block, it creates an opportunity for a draft that might just get you started. But don't forget that you are involved in that process. As far as citations and hyperlinks go, Drafting Assistant does that. I can tell you Judge Gotch, I don't know about other judges, I can tell you Judge Gotch loves hyperlinks in any briefs that come to him, just if that is useful to you. His law clerks don't mind it either, but we know he loves it, and he tries to. We end up incorporating hyperlinks most of the time into especially our larger projects at his direction. And Drafting Assistant then allows you to go back and see all of those hyperlinks it's inserted for you, and double check your citations. If you've got one wrong, it's going to tell you. And so that's a whole nother part of this proofing process. where technology really can help make what you're doing better. And of course, then all those things and then I will point out legal editing. If you could go to the next slide, Stephanie. Microsoft Word has changed. There's no longer, at least in the version we have, there's no longer spelling and grammar check. It's this Microsoft editor. And it's hard to see up there, but it gives you this window where it will outline your spelling errors, your grammar errors. It talks about clarity and conciseness. So it's giving you all of these tips, and you can go through them one by one. And it's kind of identifying those little proofreading moments, those little proofreading clues for you, and helps to make things better. That is the menu for drafting assistant, and you can see there is inserting flags and links, locating authority, play with it. I think there's some real opportunity. There are also some risks, and I'm going to let Stephanie talk a little bit about some of the risks of the technology.
Sorry, I had a fun video, but we're getting short on time, so I'm sure you can imagine. So let's think back to George. I promise that skit actually had a purpose. He demonstrated a pretty cavalier approach to using generative AI technology. So he's probably a little bit of an extreme, but I think thinking back to George and what he was doing and letting the AI just take over, it demonstrates the two overarching concerns that we've seen by this type of technology so far. Has everyone heard about the lawyer in New York who used cases that were made up by ChatGPT in filing? So, of course, that is the first concern that we know of right now, is that the generative AI is just totally unpredictable. It has a lot of gaps in its knowledge base right now, and so the way that it deals with that is to fill that gap in with made-up facts and made-up laws. And so obviously that's just problematic on its face. Like, we don't want fake laws, we don't want incorrect facts, no matter what. The problem is that it's really convincing when it does it. So it models its language after court orders, it formats its citations to look like they came from a legal reporter or from Westlaw and Lexis. And in the New York attorney case, there were actually two attorneys who were sanctioned. One of them was the researching attorney, and the other one was the attorney who had his name on the brief. But the citations looked realistic enough that it fooled both of them. So,
Well, and you said, too, it even fooled
and I think there was another associate in the firm.
and ChatGPT.
Yeah, oh, and the other thing about this that was kind of crazy from what I read is that apparently the researching attorney was concerned enough about what it was giving him that it actually asked ChatGPT, are these cases real? And it said yes. So it's very convincing. And so we don't have a lot of time, just a quick anecdote on my end to prepare for this presentation, over the last 6 months. My computer has Bing on it, and Bing now has its own AI. And so I was like, oh, I'll just ask it some stuff about the Jetsons. And it proceeded to tell me that in 2035, we are getting a Jetsons reunion show. George Jetson will be played by George Clooney, Jane will be played by Jennifer Aniston, and Rosie will be played by Scarlett Johansson. And it was telling me all this information about how it was going to be live action, and when it was going to air, and what network was going to carry it, that I actually was like, oh my God, is this happening? And I couldn't find anything about it online, but there's still a part of me that's like, I don't know, maybe it is happening. So just a funny way to explain, like, you really just don't know what this thing is going to tell you. And I think that they are working to try to make this issue better, and so there might be things we can use it for in the long run, but right now it's a professional bullshitter. And so I stole that from a blog. I can't remember. I didn't come up with it. So just one other concern I want to point out, and it's really similar to what I just talked about in the unpredictability, but it's just another way to think about it. And if you were here for Judge Lichty's, he kind of touched on this as well. As lawyers, we take an oath to be civil, respectful, to litigate cases without any prejudice or bias or personal interest. AI doesn't take any kind of oath. It doesn't care about any of that stuff. And so it doesn't have the filter that we put on the things we write and the things we say as lawyers. And so if you're taking the stuff that it gives you just wholesale, you're running the risk of having an issue from that perspective as well. So it's just another thing to keep in mind when you're using this type of generative AI. These are just a few of the rules that are implicated by these issues. I'm not going to go through all of them with you, and we have handouts of the slides. I mean, these are just a few examples. This could be a whole separate presentation, these issues. So these are just things I wanted to point out that came to mind when I was looking at this. So I wanted to end just by, because the whole point of our presentation is we don't want people to feel scared by technology. I think it really can be a valuable tool and can make your writing better, and it can help you do your job more quickly. But when we're looking at generative AI, just a few tips, things that we've found while preparing for this. First, you want to check the rules for the jurisdiction that you're planning to have your case in. So since the New York case came out, judges throughout the country have been reacting in different ways. There's at least one judge that I found, who's from the Northern District of Texas. He now requires that any filing in any case before him has a separate certification that either says no generative AI was used, or if it was used, you have to say how it was used and that you verified the information that it gave you. So you may not want to use it if you have to tell the court what it gave you. That might be kind of embarrassing and weird. So you might want to check that first before you dive into using it too much. One lesson that we can take from our New York lawyers, the ones who just kind of ask the broad-based question, are these cases real, is that we might want to be more careful about what kind of questions we ask it and how we phrase the questions, what kind of information we give it, because maybe had they asked the question in a better way, he could have gotten a better answer, or he maybe wouldn't have gotten cases that were not real. And then I think, at least for now, we might want to use this technology just as a starting point. Like Candace said, if you're having some writer's block or you're stuck in like a research circle and you can't break out of it, this might be a tool that helps you get past that. But then you don't take anything it gives you and just wholesale use it as your final product. And of course, anything it gives you, you want to double check the language, and you want to verify any citations with other sources.
And with that, we hope that the last hour, maybe we've taken you and your writing just a little bit further from good to a little bit better. We will just re-emphasize, use all the tools of your disposal. You are the tool. You and your uniquely human brain that has been legally trained, knows how to analyze things, has a moral compass. You are the most important part of this process. But don't be afraid of the new stuff, and please don't throw the old stuff out don't throw it out. The 20th century, the 19th century, the 18th century still brings to bear on the quality of writing today. And I would then encourage you to use the tension between your inner Jane Jetson, who was unsure how to proceed, and your inner George Jetson, who was anxious to limit his work at any cost, to draft more persuasive, effective pleadings, motions, and trial documents. Thank you very much.